Welcome to the Retiring Canada podcast, where our mission is to educate and empower you to make the most informed, rational, and productive financial decisions. Hosted by certified financial planner, author, and chartered investment manager Michael Isbister. You'll go behind the scenes to uncover the tips and strategies to help you invest smarter, optimize your retirement income, and reduce the amount of tax you pay. Michael is an investment advisor with Fundamental Wealth, a trade name of Harbourfront Wealth Management, a CERO dealer. And now, here's your host, Michael Isbister.
Hello everyone, and welcome again to the Retiring Canada podcast. In today's episode, we're going to discuss how to protect an inheritance from a child's spouse. Specifically, I'm going to discuss how deep client relationships lead to robust planning, uncomfortable conversations worth having, 3 options to consider to protect a gift to a child, the importance of documenting your gifts, strategies to protect inheritances in your will, and lastly, a few action items for you to consider. One of the interesting aspects of creating deep personal relationships with clients is that you tend to gain knowledge and understanding about not only their personal finances, but also their family dynamics. It's not uncommon to learn about very sensitive information that maybe myself and perhaps a handful of others may be aware of. I am humbled to be the advisor that clients can entrust with not only their financial well-being, but also highly sensitive information that never leaves the office. Today, I want to discuss an often uncomfortable conversation that comes up from time to time with clients, and some potential planning strategies to help address the issue. Here's the scenario. Mr. and Mrs. Client schedule a meeting through my online calendar requesting a time to sit down. The meeting notes say, quote, unsure about gifting money. In our meeting, we catch up and chat about our lives and share plans about what each of us have planned for the rest of the year with our families. And this is where things pivot. Well, Michael, speaking of family, we want to discuss gifting about $100,000 to our son and our daughter. But we are concerned about our daughter's husband. Things just don't seem right in their relationship, and we have concerns that if we gift this money, that if their relationship fails, he's going to walk away with half of it. Which also made us concerned about how our will may also be impacted by this. What can we do to ensure that our money doesn't end up in our daughter's husband's hands? Okay, with that scenario in mind, let's discuss a few options and potential outcomes when gifting funds during their lifetime. Option 1 is simply gifting the money to the daughter. Now, in some jurisdictions, this kind of inheritance is not exempt from a division of family property, and in others, the inheritance or gift may only be exempt if it has been kept separate and not used for family purposes. So, for example, say they went ahead and gifted this $100,000 to their daughter, and then the daughter proceeded to purchase a family asset like a home or vehicle or used it to pay down joint liabilities. Then this inheritance may actually become shareable. In some jurisdictions where the inheritance is not shareable, the growth seen from that gift or inheritance may still be shareable unless specific conditions are met, which I will share in a moment. If you want to increase the chances of an inheritance or gift being exempt from a division of family property, then the daughter should attempt to hold or keep that asset as separate as possible. In particular, the spouse should not be added as a joint holder on any investment or savings account. And the daughter should deposit the money into a completely new account, to which shareable funds are not commingled and a clear line of ownership can be traced. I would also suggest that the parents sign a declaration of a gift. indicating that the amounts are not meant to be shareable, including any income and growth derived from the gift. Even with these safeguards in place, the funds could still be subject to litigation and potentially exposed to a division of family property. Option 2 would be to loan the funds to your daughter as opposed to a gift. Now, to properly do this, certain guidelines must be followed. First, the parents and daughter would sign a promissory note and a loan agreement in order to provide evidence that the amounts are meant to be repaid. Preferably, this should be done and drafted by legal counsel. This step should be done in advance of gifting any funds and not as a contemplation afterwards. Next, it's not absolutely necessary that interest be charged in the loan, but where the loan has specific terms of interest and the interest is not paid, this may factor in the favor that the loan was later forgiven. If the loan will be outstanding for some time, it will be important to review this promissory note from time to time and potentially restart the limitations period. It's important to establish that there was an intent to repay the loan if you want to protect those funds in the event of a relationship breakdown. Option 3 is to ask the daughter to sign a domestic contract with the husband. Specific wording could be added to such contract that would ensure these gifts would be exempt from a family asset division if their relationship broke down. While this doesn't protect the parent, it does provide a high likelihood of protecting gifted assets. Now that we've covered off some options for gifting during the parent's lifetime, what will happen in the will? What happens there? In this scenario, let's just assume both Mr. and Mrs. Client name each other as beneficiaries of the will and their 2 children as the secondary beneficiaries if the other spouse has passed. In this scenario, the last passing, half of the assets would be split 50-50 between the 2 adult children. These inherited assets could be exposed to the same family law issues that were present when gifting during your lifetime. So in my example, the daughter would inherit her after-tax portion from the estate and would need to keep tight records, not commingle assets, and ensure a clear line to reduce these assets' exposure to a marital breakdown. Alternatively, a domestic contract could also be established at this time to protect the assets and inheritance. But with all that said, life is messy, and the parents want to know, is there anything we can do in our will to prevent our daughter's husband getting access to our estate assets? And the answer is yes. The option here would be to add specific wording in the will to have each of the children's 50% share payable to a family trust. So on one side, there would be a trust set up for the daughter, and any of her children, so your grandchildren, would be named as beneficiaries of the trust. The daughter would be the trustee, with specific wording outlining their discretion over the trust, the purpose of the trust, and how property is to be managed and income distributed. In essence, the daughter would receive benefit of the assets that are not considered family property, and at her passing, the funds would leap over the husband and either go to the children or grandchildren or revert to another trust, or the trust would be wound up and distributed. Now, I'm grossly oversimplifying this example. The wills that I've seen drafted for clients in this scenario are anything but basic, often pushing past 25 plus pages of legalese. So please ensure you seek legal counsel whenever adding this level of sophistication to a will. Now, as you're probably aware, in episode 79 of the podcast, I did a bit of a deep dive into trusts and when they are applicable. In the scenario I just outlined, the cost and time of setting up and maintaining a trust should be factored into whether or not it should be set up. In some scenarios, keeping assets separate with proper documentation may be applicable, or perhaps a domestic contract makes the most sense. For others, specifically when businesses, farmland, or multi-million-dollar properties or investment portfolios are involved, a family trust structure in the will may be a strategy worth considering. Okay, so that will do it for today. Here are your action items for today's episode. First off, if you're considering gifting your child, speak with them about it, especially if it's a significantly large gift. In doing so, ensure you draft and sign a declaration of a gift letter and discuss what needs to take place to keep assets separated and not commingled. Now, depending on where you live, what is possible here will change, so ensure you check with legal counsel. Number 2, if you're wanting another way to potentially protect those assets, consider structuring a promissory note to loan the funds as opposed to gifting. Lastly, have a look at your will. If you have concerns about your child's spouse and you have amassed a sizable net worth, you may want to consider adding a family trust structure to the will to shelter assets from a marital breakdown. All right, that'll do it for today's episode. Make sure you add us on all of our socials. For all of the links and resources and show notes, make sure you visit retiringcanada.ca. If you're enjoying the show, please subscribe and leave us a 5-star review in your favorite podcast app. Be sure you sign up for our weekly Retiring Canada newsletter. And hey, when it comes to your retirement, don't take chances. Make a plan so you can retire with confidence.
All comments are of a general nature and should not be relied upon as individual advice. The views and opinions expressed in this commentary may not necessarily reflect those of Harbourfront Wealth Management. While every attempt is made to ensure accuracy, facts and figures are not guaranteed. The content is not intended to be a substitute for professional investing or tax advice. Please seek advice from your accountant regarding anything raised in the content of the podcast regarding your individual tax situation. Always seek the advice of your financial advisor or other qualified financial service provider with any questions you may have regarding your investment planning.